Physically, where were Hillary Clinton's servers?
The operational server was in the basement of her home in New York. The reason I'm answering it that way is sometimes after they were decommissioned, they were moved to other facilities, storage facilities, but the live device was always in the basement.
Was that an authorized or unauthorized location?
It was an unauthorized location for the transmitting of classified information.
Is it reasonable or unreasonable to expect Hillary Clinton would receive and send classified information?
As Secretary of State, reasonable that the Secretary of State would encounter classified information in the course of the Secretary's work.
Via email?
Sure, depending upon the nature of the system. To communicate classified information, it would have to be a classified rated email system.
But you did find more than 100 emails that were classified that had gone through that server, correct?
Right, through an unclassified server, correct.
Yes. So Hillary Clinton did come to possess documents and materials containing classified information via email on these unsecured servers, correct?
That is correct.
Did Hillary Clinton lie?
To the FBI? We have no basis to conclude she lied to the FBI.
Did she lie to the public?
That's a question I'm not qualified to answer. I can speak about what she said to the FBI.
Did Hillary Clinton lie under oath?
Not to the FBI, not in a case we're working.
Did you review the documents where Congressman Jim Jordan asked her specifically, and she said, quote, "There was nothing marked classified on my emails, either sent or received," end quote.
I don't remember reviewing that particular testimony. I'm aware of that being said, though.
Did the FBI investigate her statements under oath on this topic?
Not to my knowledge. I don't think there's been a referral from Congress.
Do you need a referral from Congress to investigate her statements under oath?
Sure do.
You'll have one. You'll have one in the next few hours. Did Hillary Clinton break the law?
In connection with her use of the email server, my judgment is that she did not.
Did you just not able to prosecute it, or did Hillary Clinton break the law?
Well, I don't want to give an overly lawyerly answer. The question I always look at is there evidence that would establish beyond a reasonable doubt that somebody engaged in conduct that violated a criminal statute? And my judgment here is there is not.
The FBI does background checks. If Hillary Clinton applied for the job at the FBI, would the FBI give Hillary Clinton a security clearance?
I don't want to answer a hypothetical. The FBI has a robust process in which we adjudicate the suitability of people for employment in the Bureau.
Given the fact pattern you laid out less than 48 hours ago, would a person who had dealt with classified information like that, would that person be granted a security clearance at the FBI?
It would be a very important consideration in a suitability determination.
You're kind of making my point, Director. The point being, because I injected the word Hillary Clinton, you gave me a different answer. But if I came up to you and said that this person was extremely careless with classified information, the exposure to hostile actors, and used, despite warnings, created unnecessary burdens and exposure. If they said that they had one device and you found out that they had multiple devices, if there had been email chains with somebody like Jake Sullivan asking for classification changes, you're telling me that the FBI would grant a security clearance to that person?
I hope I'm giving a consistent answer. I'm not saying what the answer would be. I'm saying that would be an important consideration in a suitability determination for anybody.
And it's just, personally, I just think that sounds like a bit of a political answer, because I can't imagine that the FBI would grant a security clearance to somebody with that fact pattern. Do you agree or disagree with that?
Just say what I said before. Again, it's very hard to answer in the hypothetical. I'll repeat it. It would be a very important consideration in a suitability determination.
Did Hillary Clinton do anything wrong?
And what do you mean by wrong?
I think it's self-evident.
Well, I'm a lawyer, I'm an investigator, and I hope a normal human being.
Do you really believe there should be no consequence for Hillary Clinton and how she dealt with this?
Well, I didn't say, I hope folks remember what I said on Tuesday. I didn't say there's no consequence for someone who violates the rules regarding the handling of classified information. There are often very severe consequences in the FBI involving their employment, involving their pay, involving their clearances. That's what I said on Tuesday, and I hope folks walk away understanding that just because someone's not prosecuted for mishandling classified information, that doesn't mean if you work in the FBI, there aren't consequences for it.
So if Hillary Clinton, or if anybody, had worked at the FBI under this fact pattern, what would you do to that person?
There would be a security review and an adjudication of their suitability, and a range of discipline could be imposed from termination to reprimand, and in between suspensions, loss of clearance. So you could be walked out, or you could, depending on the nature of the facts, you could be reprimanded. But there is a robust process to handle that.
I've gone past my time. I yield back. Now recognize the ranking member, Mr. Gowdy, for 5 minutes.
Good morning, Director Comey. Secretary Clinton said she never sent or received any classified information over her private email. Was that true?
Our investigation found that there was classified information sent.
So it was not true?
Right. That's what I said.
Okay. Well, I'm looking for a little shorter answer, so you and I are not here quite as long. Secretary Clinton said there was nothing marked classified on her emails either sent or received. Was that true?
That's not true. There were a small number of portion markings on, I think, 3 of the documents.
Secretary Clinton said, I did not email any classified material to anyone on my email. There is no classified material. Was that true?
There was classified material emailed.
Secretary Clinton said she used just one device. Was that true?
She used multiple devices during the 4 years of her term as Secretary of State.
Secretary Clinton said all work-related emails were returned to the State Department. Was that true?
No, we found work-related emails, thousands, that were not returned.
Secretary Clinton said neither she nor anyone else deleted work-related emails from her personal account. Was that true?
That's a harder one to answer. We found traces of work-related emails on devices or in Slack space, whether they were deleted or whether when a server was changed out, something happened to them. There's no doubt that there were work-related emails that were removed electronically from the email system.
Secretary Clinton said her lawyers read every one of the emails and were overly inclusive. Did her lawyers read the email content individually?
No.
Well, in the interest of time, and because I have a plane to catch tomorrow afternoon, I'm not going to go through any more of the false statements, but I am going to ask you to put on your old hat. False exculpatory statements, they are used for what?
Well, either for a substantive prosecution or for evidence of intent in a criminal prosecution.
Exactly. Intent and consciousness of guilt, right? Is that right?
Right.
Consciousness of guilt and intent. In your old job, you would prove intent, as you just referenced, by showing the jury evidence of a complex scheme that was designed for the very purpose of concealing the public record. And you would be arguing, in addition to concealment, the destruction that you and I just talked about, or certainly the failure to preserve. You would argue all of that under the heading of content. You would also be arguing the pervasiveness of the scheme, when it started, when it ended, and the number of emails, whether they were originally classified or up-classified. You would argue all of that under the heading of intent. You would also probably, under common scheme or plan, argue the burn bags of daily calendar entries or the missing daily calendar entries as a common scheme or plan to conceal. 2 days ago, Director, you said a reasonable person in her position should have known a private email was no place to send and receive classified information. You're right, an average person does know not to do that. This is no average person. This is a former First Lady, a former United States Senator, and a former Secretary of State that the President now contends is the most competent, qualified person to be president since Jefferson. He didn't say that in 08, but he says it now. She affirmatively rejected efforts to give her a state.gov account. She kept these private emails for almost 2 years and only turned them over to Congress because we found out she had a private email account. So you have a rogue email system set up before she took the oath of office, thousands of what we now know to be classified emails, some of which were classified at the time. One of her more frequent email comrades was in fact hacked, and you don't know whether or not she was. And this scheme took place over a long period of time and resulted in the destruction of public records, and yet you say there is insufficient evidence of intent. You say she was extremely careless, but not intentionally so. You and I both know intent is really difficult to prove. Very rarely do defendants announce, on this date, I intend to break this criminal code section. Just to put everyone on notice, I am going to break the law on this date. It never happens that way. You have to do it with circumstantial evidence. Or if you're Congress and you realize how difficult it is to prove specific intent, you will formulate a statute that allows for gross negligence. My time is out, but this is really important. You mentioned there's no precedent for criminal prosecution. My fear is there still isn't. There's nothing to keep a future Secretary of State or President from this exact same email scheme or their staff. And my real fear is this. It's what the chairman touched upon. This double-track justice system that is rightly or wrongly perceived in this country. That if you are a private in the Army and you email yourself classified information, you will be kicked out. But if you are Hillary Clinton and you seek a promotion to commander-in-chief, you will not be. So what I hope you can do today is help the average person, the reasonable person you made reference to, the reasonable person understand why she appears to be treated differently than the rest of us would be. With that, I would yield back.